You are, first of all, hello everybody, and thanks very much for being here today. I'm joined by some of my colleagues. I think that Patsy and Siobhan are with me from the Decision Support Service, and delighted to speak again to Family Carers Ireland and their membership. We are very conscious of the concerns and some of the valid apprehensions that people have around the introduction of the 2015 Act and the work of the Decision Support Service, and we're going to do our level best to give you an introduction to the Act, the work of the service, and to address some of those concerns. And as Catherine has said, this presentation takes something like 25 minutes or half an hour. I'm available for questions afterwards, and any questions that you feel haven't been addressed, I know we're going to try and pick up on. Carers are a really important stakeholder for the service. We speak to a whole diversity of stakeholders, but many of them have their organisations behind them. They have their representative organisations and their regulatory bodies. So I feel that we really do need to make sure that carers are getting the support, because you're doing the work in your own homes and very much on the front line. We want to make sure that we are reaching you. So in the hope that this is working and that I'm now moving down through the presentation. Okay, I hope you can see Michael D there. So the Assisted Decision Making Capacity Act is an act. It is enacted law, and it was signed into law after a really long lead time and lots of attention during the legislative process. So it's been a finalised act for more than 5 years now. We're past the 5th anniversary. And these are the key things, I suppose, that the Act is about, and it focuses on decision-making capacity. So when we talk about capacity, what we mean is that ability to make your own decisions, and the Act is about facilitating people to make their decisions by themselves and how we support them if they have problems in doing that. It applies only to adults, and that means over 18, and it's not operational yet. So where I say it is enacted law, it hasn't gone through the process which is called commencement. Some bits of it are commenced, including my own function. But a lot of the reforms that I'm about to speak to haven't gone through that commencement process. And that's a relatively simple kind of legislative exercise further down the line, where the ministers sign another order and that brings the rest of the Act to life. And the key reforms that the Act introduces are these: the abolition of the wards of court system, which has been with us for, it's past its 150th anniversary, under the, I'm afraid it's still called the Lunacy Regulation, Ireland Act of 1871. So a Victorian statute under which wardship is still largely administered, and that's repealed by the 2015 Act. The 2015 Act repeals that Act insofar as it administers adult wardship, and also something called the Marriage of Lunatics Act, I'm afraid, of 1811, so a really antique piece of legislation which would have prohibited wards of court from marrying. And just to bring you bang up to date, that actually now has been repealed. So that's a bit that is commenced, and that happened on the 1st of February just this year in response to a High Court case. So a ward of court is not now prohibited from marrying simply by being a ward of court, if that makes sense to you. So apart from the abolition of the wards of court system, the Act introduces a statutory functional test of capacity. I'll say a little more about that. New guiding principles, which are largely inspired by the United Nations Convention on the Rights of Persons with Disabilities. A brand new 3-tier framework for supported decision making, and new and improved tools for advanced planning, which all of us should consider, and then the establishment of the Decision Support Service with our particular statutory functions. Again, I'll say more about those. Okay, when I talk about the relevant person, that's at the heart of all of our considerations. The relevant person is the focus of the Act and the focus of the Decision Support Service. And that's the person whose capacity is in question or may shortly be in question in relation to a particular decision. So I guess for this audience, really, when you think about the relevant person, that's probably the person that you are caring for. Okay, a little word about wardship and how it operates at the moment. It's been described as a blunt instrument approach, because when somebody is taken into wardship, the court, and it's almost always the High Court, declares that person to be a person of unsound mind. So it's a kind of status approach. And then the court becomes the decision maker. So a person is often taken into wardship to deal with one big decision. It could be to do with the management of an award of compensation or an inheritance, or to take a significant decision around healthcare, for example. But when the High Court moves into that role as decision maker, it has that effect of taking away their autonomy around many other small decisions, like applying for a passport. Routine healthcare, day-to-day decision making devolves away from that person when they're a ward of court, even though they were only brought into wardship because of a significant matter that needed attention. So when the Act is commenced, there will from day one be no new applications for adult wards of court, and all current wards of court will be reviewed and must come out of wardship within 3 years at the latest. And we think that there are around 2,300 to 2,500 of those adult wards, and it's the Office of the Wards of Court who will manage that transition. I think it's important to say that any of those wards, and some of you may be caring, a minority of you may be caring for somebody who is a ward of court already, and any of those current adult wards of court can actually fast track that process by bringing their own application to the wardship court to ask to have their cases reviewed. So it isn't necessarily going to take as long as 3 years. And also, yes, wards under 18 are going to age out and age into this process, I suppose, during that 3-year transition period, and have to be reviewed as well. The functional assessment of capacity. Okay, so the Act asks, do you have capacity to decide a particular thing at the time that you need to decide it? So it's a move away from that you are a person of unsound mind approach, so that capacity is always assessed relative to the decision that needs to be taken at the time that you need to decide it. Importantly, there isn't a kind of medical or diagnostic entry point to that. So that a lot of people who come under the Act and benefit from the Act may be people who have a diagnosis of, for example, intellectual disability, enduring mental illness, acquired brain injury, or age-related cognitive impairment. But that's not, that isn't necessarily how you come in under the Act. So that a medical condition only matters if it is actually affecting your decision making. So the Act has been written in a way that's described as disability neutral. So as I've previously expressed it, you lack capacity is not a full sentence. It isn't tenable to say any longer, this is somebody with no capacity, because capacity is always, whatever somebody's presentation, it is always to be assessed relative to the thing that needs to be decided. And I'll come back to that. I know that that sometimes provokes questions. And this is how that assessment is carried out. So it's a 4-part assessment. So thinking about a decision and thinking about the information which is relevant to that decision. A person lacks capacity if they can't do all of the below. Understand that information. Retain the information for as long as you need to in order to make the decision. Weigh up and evaluate that information, and then communicate a decision, but with support if necessary. So the fact that somebody needs interventions around their communication doesn't mean that they lack capacity, and they may need easy read. They may need somebody who's able to explain it to them in a way that they can understand. They may need assistive technology or sign language or speech and language therapy. Whatever those supports are, you can't conclude that somebody lacks capacity unless those supports around communication have been made available. Now, I've referred to this as a statutory test because it actually is already the proper test, because the court identified it more than 12 years ago now in a case about capacity to refuse a blood transfusion, a case called Fitzpatrick. So the High Court said, identified that this is what a proper approach to assessing capacity looks like. And we already see this approach in other policy and standards in, for example, the HSE National Consent Policy. It's already called out in Irish Medical Council guidelines. So what this Act does is to take that approach and that common law test that the courts came up with and put it into written law. The guiding principles are introduced under Section 8 of the Act. So these guide what are called interveners under the Act. And the first of these is the presumption of capacity. so that you don't start off by thinking, here is somebody who has an acquired brain injury and intellectual disability, and therefore I have to think that there's a problem with capacity. Instead, you start off by thinking that everyone can make their own decisions, and assessing capacity isn't the first step. Can I say as well, this presumption of capacity, again, is already with us. It has already been identified at common law. It's already supposed to be the approach in Wordship, and it's already in policy and standards. So again, it's something which the Act is just putting into written law. So the first step isn't to assess somebody's capacity. The first step is to support people as far as possible to make their own decisions. Wanting to do something that seems unwise doesn't mean that you lack the capacity to decide to do it. And that's sometimes misleadingly shortened to the right to be unwise, which isn't what the Act says. Instead, what the Act says, as I've put it here, is that the fact that you want to do something which doesn't seem like a good idea doesn't mean necessarily that you lack the capacity to do that very thing. The Act calls out respect for dignity, privacy, bodily integrity and autonomy, lots of buzzwords that you'll see around the language of the UN Convention on the Rights of Persons with Disabilities. You have to include the person in their decision making, making sure that they're participating as far as possible in the decision making that matters to them. And again, this is UNCRPD stuff, respect for will and preferences, past and present will and preferences, instead of the idea of best interests. Now, you'll still see best interests mentioned in other documents in law, and it's actually the standard in other countries. But the UNCRPD committee would say best interests is consigned to the past. It has all of those kind of ideas of paternalism and deciding what's good for a person, which this country loved doing for a long time. And instead, we have as a gold standard will and preferences. And again, as well as that, then the duty to act in good faith at all times and for the benefit of that relevant person. Happy to discuss those principles more as well. So when I talk about decisions, well, what do we mean? What are the sort of decisions which are capable of being supported under the new framework? And the Act divides those broadly into two categories. So you've got property and affairs and personal welfare. And both are quite broadly defined with catch-all provision, so that personal welfare includes things like deciding where you live and who's going to take care of you, your health, which can include medical decisions. And under property and affairs are matters like buying, selling, renting a house, or how you would manage a bank account or apply for benefits. So they're quite broadly defined, and those are all of the sort of decisions which are captured by the Act and which can be supported under the new framework. And this is an outline of that new framework. So this is completely new. At the lowest tier, then you have the Decision-Making Assistant, where the person is still making their own decisions, but with help. Codecision Making right in the middle, which as the name suggests is joint decision making. And then at the top tier, there's still provision for a court supervised process, the Decision-Making Representative, who is appointed by the Circuit Court. So a move away from the High Court to the regional circuit courts in the hope that that would be less costly and more accessible. And I'm going to say a little more about each of these in turn, but these considerations apply to the tiers, so that there are suitability and eligibility criteria across all the tiers, so that a person mightn't be suitable to step into one of these supporting roles based on kind of pragmatic things like a criminal record in certain cases, and also where somebody is residing in services, then the owner, a registered provider, or an employee of those residential services isn't eligible to step into these roles. Or if somebody has supports themselves under the Act, then they are ruled out from stepping into these roles in certain cases. All supporters must apply those guiding principles that I've mentioned. And this is of interest sometimes when you are applying for these supports to be put in place. So you're registering an arrangement with the Decision Support Service, or you are applying to court, you have to give notice to certain other interested parties, and that's written out in the Act, so that if I were, for example, applying to the court for a declaration of capacity around the person that I care for, and asking the court to consider making me the decision-making representative, I actually have to tell other decision supporters who might already be in the mix, and family members, to avoid, I suppose, a situation where suddenly 3 or 6 months down the line, one sibling goes, hang on, is our sister suddenly mum's decision-making representative? Why didn't we know that that was happening? So there is provision for notice to be given to other parties, including family members. And I imagine that's in there just because of the way that family dynamics can sometimes work. And talking about family and next of kin, okay, and this describes the current position, which bluntly is this, that when you're an adult, your next of kin has no automatic legal status to make your decisions for you. And that can be a bit of a reveal to people who have always assumed that they can. So your next of kin cannot, in fact, step into that role and has no automatic, as I say, entitlement to do so. And they can't consent or refuse consent to medical treatment. And I think there is an understandable and long established misapprehension that next of kin can do exactly that. And that's not the case and never has been the case. And the Act isn't changing that. Instead, the Act, I suppose, is providing an alternative, properly recognised and authorised role so that the person in that next of kin relationship has proper certainty about what they can and can't do to provide support to the person that they care for. Having said that, it remains the case, and has always been the case, that close family members always have that important role to play because they know you best and can provide information about your wishes and your will and preferences. And that is still the case after the Act begins. It will remain appropriate to confer with close family members to try and get a sense of what the relevant person would want. And there may be more questions around that. Okay, going back to those tiers, and I'll go quickly through the 3 different tiers. So the lowest one, if you remember, was the Decision-Making Assistant. And that's someone whom you trust to help you obtain and understand information and understand the choices available to you. And you may have a Decision-Making Assistance agreement then to set out the things that you want your person, your DMA, to help you with. You still make the decision by yourself, but the DMA can help let other people know about your decision and help ensure that your decision is carried out. So it's the lowest level kind of support, really about gathering up, explaining information and communicating what the relevant person wants to do. And that could be helpful, I suppose. I'm thinking about an example. I mentioned it on Wednesday. Patsy had just mentioned it to me. We got a call about somebody saying, my father has an age-related impairment. I'm trying to deal with one of his bills, but the utility won't talk to me because he can't say that it's all right to talk to me. And I'm just trying to sort it out. He's forgotten to pay it for the last 3 months. I don't want the lights to go out or whatever it was. But they were in this kind of a bind because the utility was saying, well, who are you? And this person could be a decision-making assistant, and that might smooth that whole process. The middle tier then, if you remember, the Codecision Maker. So this is where you choose somebody to make decisions with you, a close friend or a family member that you trust, and then you write all of that out in a co-decision making agreement that sets out the sort of things that you're going to decide together. And that co-decision making agreement is registered with the DSS. There's a fair bit more formality around that than there is with the lowest tier. The co-decision maker then has so imagine that the two of you are making decisions together, but you disagree on what the decision needs to be. Your co-decision maker shouldn't stand in your way unless there's a risk of serious harm. And this arrangement is supervised by the Decision Support Service. So the co-decision maker acting within that agreement has to file certain reports with us on an annual basis, so that we're sure that they are doing that properly, and that the decision-making agreement is working well, and that where decisions are being taken jointly, that it is really a joint arrangement. And then at the top tier, as we said, is the decision-making representative. So this involves an application to the circuit court, and you're asking the circuit court there to make a declaration around a person's capacity or incapacity in respect of certain decisions or decisions. So the person who brings the application could be one of a number of people. It actually could be the relevant person themselves who wants clarity on something. It could be ourselves in the DSS. We may be the applicant of last resort where a thing isn't getting moved along. It could be services, could be the HSE in the way that the HSE often bring applications for wardship these days. Or it could be a family carer who has come up against a situation where certain decisions need to be made. There's a serious question mark about their loved one's capacity to make those decisions. Clarity is required and appropriate supports need to be put in place. So if the judge decides that you cannot make certain decisions, even with lower tier support, so important to say, it's always kind of the least interventionist approach. So the court might say, okay, you think that a DMR, upper tier support, is required here, but have you looked at whether a co-decision making agreement would work or a decision making assistance agreement would work? And if it seems that they wouldn't, and that we are definitely on the upper tier, the judge can then actually make the decision himself or herself for you, and might choose to do that where it's a once-off decision and where that is going to be the least interventionist thing to do. Or the court could appoint a decision-making representative to step in and make those decisions for you. When the court is arriving at that conclusion, the court has to listen to you. And I'm talking, when I say you here, I'm talking about the relevant person. So the court has to listen to the relevant person and to others who care about you, and also to think about the family relationships and how to make those work and preserve them as far as possible. The court must consider whom you, the relevant person, wants to be the DMR. And if nobody suitable is available, and ideally it will be that person in a close family relationship. So carers can sometimes feel they're going to get bumped out of the way, and the court is going to bypass them and decide that they don't suit to be the DMR. The court has to give preference to that if possible. But if there isn't anybody suitable available, the court can ask us in the DSS to nominate two DMRs from a panel that we will maintain, and then the court can appoint one of those panel member DMRs. But that panel member DMR is always going to have to apply the guiding principles and always going to have to confer where appropriate with family members and people close to the relevant person. The Act amends the Civil Legal Aid Act so that legal advice and aid will be available. As far as the relevant person is concerned, the relevant person doesn't have to satisfy the means test in order to get a certificate of legal aid, although if after the event it turns out they actually are somebody of means, the legal aid board could seek to recover some of the funding, but it's intended, I think, to simplify the process, and access to aid and advice and legal aid and advice will be available for family members also, with a couple of more criteria in place. I've spoken to the Legal Aid Board recently about how all of that is going to work, so I hope we'll have clarity on that shortly. So that's with the Legal Aid Board. Okay, and a little bit more then on the role of the decision-making representative. So they take their authority from the court order. So if you're appointed as the DMR for the person that you care for, you're acting within a court order. So the court decides what you can do or not do, but I don't think the intention is that you have to go to court every week because another thing has come up. Instead, I think that these orders should be made within a kind of range of decisions, so that you have your sort of license to act as your loved one's DMR, and it's very clear what's in scope and not in scope. Interestingly, and again, I think this is probably consciously put in there because this kind of thing can come up, the court can't authorise you, and a decision-making representative can't be allowed to stop you seeing other people. I think we can do this, the equivalent in the UK can do it, and it seems to come up a lot, where the court-appointed person would say, okay, I've moved in to take this decision-making role, and I'm going to prevent these three people from seeing Dad. Not a great thing to have to deal with. So under our Act, that actually isn't something that a DMR can do. So the DSS, again, has a supervisory role. We supervise and receive reports from the decision-making representative, and if they've been appointed to deal with property and affairs matters, then they're obliged to file reports with us after 3 months, and after that, DMRs report always on an annual basis. I think it's important to say our job is not to try and catch you out. We're not taking a kind of auditor approach to it. Our job is to support a DMR to be the best supporter they can, thinking all the time about the relevant person and how best to look after their rights. So in supervising and carrying out that regulatory role, our focus is to ensure that the DMR is being the best DMR that they can be, so that the relevant person's rights are being upheld. And we're going to help with that with guidance and how-to documents and template forms to try and streamline that process and make it as accessible as possible to you. Okay, a word or two about advanced planning. So that 3-tier process is new. Advanced planning is already in place in one form or another, and some of you might have questions about EPAs that are already executed or registered on behalf of the person that you care for. So this is always true of an EPA. While you are still able to decide, you can make a document called an EPA, enduring power of attorney. And in that document, you appoint an attorney, somebody that you trust to make the right decisions for you in the future. You decide what sort of decisions your attorney is going to make for you. And it's really an opportunity for that person to be your agent or your voice to ensure that if you lose capacity at a future point, and any of us could, you know, acquired brain injury, an illness, an age-related cognitive impairment, we should all plan ahead so that your EPA only starts working when you're no longer able to make these decisions by yourself. So they already exist under an act called the Powers of Attorneys Act of 1996. If you have one already in place under the 1996 Act, then they remain valid. They're not negated when the new Act commences. But if you make one post commencement of the new Act, then you do so under the new Act. What is new is that these EPAs will start to be supervised, the new ones will be supervised by the DSS. So again, they have reporting duties, they will file reports with us so that we're able to ensure that everything is on track and nothing has, you know, gone out of control. And the only other thing to say about the older ones is that there is a complaints and investigations process. So an attorney acting under a 1996 EPA is accountable to us only in the sense that a complaint about them comes to us instead of to the court, which is the case at present. And the other sort of advanced planning that the Act deals with is the Advanced Healthcare Directive. So that's a legal document in which you let people know your wishes about medical treatment. Like an EPA, it only starts to work when you're no longer able to make these decisions for yourself. And in it, you set out the things that you wish for by way of treatment and the things that you would want to refuse by way of treatment. And when you have such a document in place, a treating healthcare professional is required to adhere to it. There's a bit of a difference between wanting something and refusing something, so that if you're saying, I want this form of treatment, they're obliged to consider that. It's mandatory in the sense of refusing treatment, so that they have to do that. And it can in fact go up to including life-sustaining treatment. You can also appoint a new person called a designated healthcare representative, like an agent again, who will make decisions in the future about those medical treatments to ensure that your wishes, as expressed in your Advanced Healthcare Directive, are respected. And then a little about the Decision Support Service, our service. Okay, so it's a new service set up under the Act. Our vision for it is that it's an outward-facing, person-centred service. We're located in the Mental Health Commission, but we do a different job from the Mental Health Commission. It's where we found our home, and it is a good home because the Commission has important experience of reforming legislation and setting up new structures. But it's quite different from all of the other functions that the Mental Health Commission currently carries out, which are mostly concerned with acute mental health services. We're pleased to say that we do have a go-live date, which wasn't the case for a while, but we are now working towards getting ready for commencement in the middle of 2022. So the rest of the Act has commenced. The DSS opens its doors in around June or the 1st of July of next year. And what will we do? So the Act sets out the duties that the Director of the DSS must carry out, and these are some of them. So broadly speaking, we promote awareness and confidence about the Act, information about the decision supports that I'm talking about here today, answering questions about how to be a decision supporter. We provide information and guidance to organisations and bodies. We maintain a register of decision support arrangements and carry out those supervisory functions that I've mentioned. We have a duty to investigate complaints arising in decision support arrangements, to promote organisational change and to make recommendations about the Act. So I think from early days, we'll be getting a sense of what's working well and what's not working so well. And we can right away actually make recommendations to our parent departments about what might need to be rethought and amended. One part of getting ready also will involve drafting and publishing codes of practice and other forms of accessible guidance. So there is provision in the Act for, I think it's something like 14 separate codes of practice. We have draft codes with us already, and we're working through those, and we plan to publish those. We'd hoped to do so already. Really, the blocker has been the fact that the Act itself is undergoing some amendment. Now, you might think it took them long enough, they haven't even commenced it yet, and they're already amending it. But actually, I see that as a good thing, because when we have sat down with the Act and other organisations have sat down with it, we have seen things in the text of the Act that we think could be reworked to make it work better and really deliver for people. So amending legislation is expected before the end of this year. And it's for that reason that we have held off going out with codes of practice to ensure that they align to the finished piece of work, the finished Act. But many of the changes that I've spoken about today, we don't see those being changed. Largely they're technical, but we just want to make sure that we're not going out with codes that we need to change when we see amended legislation. We'll be encouraging families, carers, and everybody else who's going to be affected by the Act to read those codes of practice and to use them for help. There will also be codes of practice for professionals, including healthcare professionals, social care professionals, lawyers, financial service providers, and others, to make sure that they are following the Act. And these codes of practice will go out for public consultation and will be ready and published and there to use before the DSS opens its doors. I think it's probably important to clarify what we don't do. So we aren't the decision maker. In some other countries, the DSS is called the public guardian and/or the public trustee, and actually steps in and makes decisions for people when there's no one else to do so, and that's not our job. We don't have a role ourselves around managing people's money and property. Well, there is one tiny subsection in the Act which says that we might have to as an absolute last resort, but we don't think that's going to be commenced, so you can keep an eye on that. But broadly speaking, we don't take over where the Wards of Court Office left off and assume responsibility for managing people's resources. We do not directly appoint decision supporters. Sometimes we get asked, well, can you send me a co-decision maker? That's not what we do. I've mentioned that we maintain a panel of, at the upper tier, decision-making representatives, and we can nominate them to the court when asked, and the court makes the appointment. We are not an independent advocacy service. Sometimes there's a sense of blurring of the lines there, but advocates are the decision supporters that I've described have particular statutory functions, and they are different from the functions carried out by an advocate. We do, as I've mentioned, regulate and supervise arrangements, but only those arrangements that are formally with us under the Act. So if other things are going on and people have their own way of doing things, we don't know about them. We can only regulate and supervise what gets reported, what is registered with us and comes under the framework of the Act. So in the same way, we aren't a regulator of other professionals or services or people. We're not going to go into people's homes when this Act begins and say, you do know you're doing that wrong. We actually don't know about those arrangements. We can only know when they are notified to us and when people come in under the framework. People ask about these. I suppose they create concern. They're not at the forefront of our considerations, but the Act does create a number of offences, so that it's an offence to make a person enter into a supported decision-making arrangement. So if you use force or coercion to make somebody sign up to a co-decision-making agreement or to sign an EPA, for example, well, that's an offence, and it should be. It is an offence, a summary offence, not to cooperate with an investigation by the director. So if we have received a complaint and we're carrying out an investigation, we need to gather up documents or hear from somebody, you have to cooperate with that. And that's no different from other bodies that have similar powers. It's an offence to put false information into any of the documents required in order to register an arrangement. So if we have looked for, as we do in co-decision making agreements, you have to supply capacity statements or character references. If they're forged, as you can imagine, that's an offence. And it is an offence for a decision supporter to ill-treat or neglect the relevant person. But it isn't an offence to make mistakes when you are a decision supporter, or to make an error in a report that you file with us, or to file it late. That's not a criminal offence, and the Act doesn't say that it is. We will help people in those circumstances, as I say, to try and get the arrangement on track. But there may come a situation where it's clearly not working, and then we can intervene to have that decision supporter replaced. That's very different from making it an offence under law. What can you be doing to get ready? So the relevant person, the person who's at the heart of the Act, might be asking themselves these questions while we think about commencement. How are my decisions being managed at present? What are those decisions? What do I come up against? What property and affairs or personal welfare decisions do I need to make, and what could arise in the future? And who would be suitable to act as one of these decision supporters if necessary? I don't want people to think that we press go and everybody needs to move into one of these formal arrangements. That may not be true in somebody's individual circumstances. So I think it's important to begin that conversation with family and friends, and also to think, can I be planning ahead by way of an enduring power of attorney, or perhaps an advanced healthcare directive? All of us can be planning ahead, in fact, and should do so. So, and this is my last slide, we need to make sure that what we're doing here is compliant with the UN Convention on the Rights of Persons with Disabilities, which guarantees full human rights for all persons with disabilities without discrimination. And I don't think anyone would argue with that, or with the right to recognition everywhere of a person with disabilities as a full person before the law, with legal capacity on an equal basis with everyone else. And that means that entitlement to hold and to exercise rights, because loss of decision-making capacity isn't and should never be an off switch for your human rights. And that is it from me. Happy to take questions. I have put up there our website address, and you'll find on it, we've had the website in place since last summer. So on it we have lots of, I hope, accessible information around the Act, including a section of what you can be doing to get ready. And that is it from me in the presentation for a moment. So I'll hand back to Catherine, I think, and I'm happy to take your questions. I'll stop sharing.